Good afternoon. I'm Rugi Canizares, your treasurer. I'm your host for today's Regulatory Hour webinar. We all by now know Dale very well, and FSBPT is fortunate and grateful to have Dale Atkinson on an ongoing basis. Briefly, Dale's background: Dale received his law degree at Northwestern School of Law, Portland, Oregon, and is the sole managing member of Northbrook, Illinois law firm Atkinson and Atkinson, and he represents various associations of regulatory boards. A couple of reminders: housekeeping. Dale prefers questions in the chat section, and the next FSBPT educational offering will be on March 1st at 4 p.m. Eastern Standard Time. The when, how, and why of MPTE design presented by Lauren Mueller and Colleen Letvin. And for board administrators in the audience, the CBA forum is on March 24 at 4 p.m. Eastern Daylight Time. Please remember, March 12th, we spring forward. Please sign up for both offerings through the portal, just as you did today, and thank you. I'm pleased to have Dale present today's Regulatory Hour topic. For this month's Regulatory Hour, he will focus on the impaired practitioners and the role of regulatory boards as it relates to licensure, balancing the statutory intent of public protection and the licensee's needs and rights. Let's welcome Dale as he presents regulation and the impaired practitioner. Thank you, Dale.
Thank you, Rugi, and I hope you all can, one, see the screen, and two, you can hear me. So Rich, give me a thumbs up. You can hear me. Sound is good. Excellent. And so, thank you, Rugi, for that introduction. And if I may, I'll put the plug out as well for these upcoming webinars that your organization holds, and encourage you to attend. It's an opportunity to learn from each other. That's how I look at these as well. So to emphasize what Rugi said, if someone has something they would like to say or ask, please feel free to use the chat, or if you're able to raise your hand, we can unmute. However that can best work to ensure that that this is an interactive session. And so again, many thanks for getting us started here, Rugi. We will stick to our time and our topic here. So let me see if I can advance my slides. So in addition to encouraging you to attend the webinars of your organization, and as Rugi said, as he introduced me as to what I do, I do represent a whole bunch of FSBPT-like organizations, and so I encourage you to understand the programs and participate. But as we begin here today, I do want to thank the FSBPT Board of Directors for dedicating the time and resources to have these webinars. And I certainly appreciate and am thrilled to be a part of them. And so big shout out, thanks to the board of directors, and another big shout out, thanks to the FSBPT staff who operationalize these webinars. And they all deserve a gigantic thank you. But the biggest thank you, I believe, goes to you all who are on the line today, and the important role that you play in public protection, enforcement of the Practice Acts, and the licensure process of physical therapists and physical therapy assistants. And so you're not thanked enough. We are in a climate right now of scrutiny on the regulatory community. And by the way, I welcome the scrutiny, and I hope that you do as well, but that scrutiny can sometimes lead to political issues, statutory and regulatory changes, and otherwise. And so I think the more we, as the regulatory community, the we is myself and all of you, the more we know and can articulate the important issues related to regulation, I think the better off we all are related to the climate that we are living in. And please feel free to rely upon the FSBPT for some assistance, and that's what these are all about. And so as your facilitator today, I've been introduced. I'm an attorney outside of Chicago, Illinois, and you can see there a lawyer as a person who writes a 10,000-word document and calls it a brief. And so for those of you who have been attending these, usually I put up a picture of some famous lawyer or some actor lawyer, but today we'll do a little different approach. As a reminder, because I do represent FSBPT-like organizations, a reminder that this is your organization, and take advantage of the programs and services that are offered to you that hopefully help your board at the state jurisdictional level be as efficient and as effective as possible. So one of those programs, of course, is these webinars as well. So now that that pesky Super Bowl is out of the way and over with, and to make sure you all are listening and engaged here, feel free to go ahead and type into the chat who you think is going to win the Stanley Cup. I do have a picture of the Blackhawks there, and I can guarantee you the Blackhawks are not going to win the Stanley Cup, but feel free to put the Blackhawks in there anyway. And that will, of course, I think, bolster all of our egos. So we got some Penguins and some Capitals. So we've got some Washington people that are probably tuned in here today. And so the idea here is to get you to use these chats. And so feel free to type in at any point in time. I keep an eye on it, but Rugi and Rich and the staff, feel free to interrupt me if there's a chat that comes in. And so only a couple answers. So somebody type something else in there to make sure I know that you're out there. Now, regulation and the impaired practitioner. This is it's a very timely, it's an extremely important topic for us to address, for us as in the regulatory community. And I will tell you this, I am going to be all over the map in this next hour here today about the various approaches to impaired practitioners. And so we can view it from the regulatory side. You all, many of you, most of you are board members or staff of state boards, and your role is to enforce the Practice Act consistent with the intent of the legislature in the interest of consumer or public protection. Okay. So you have a very important role as to how impaired practitioners are addressed when it comes to the safety of the consuming public. At the same time, in kind of the climate that we're in, there not only is this a regulatory climate, but it is a climate of sensitivities to all sorts of issues, and an impaired practitioner is one of those. So I think as we discuss today, and as we kind of go through these slides and talk about the options and the opportunities for not only the boards, but we also have to be sensitive to the practitioner, him or herself. And there are so many issues out there in all the professions. And as mentioned, I work with a lot of professions, and the issue of burnout, the issue of impairment, the issue of mental health matters that can surface for licensees is extremely important, that we, the regulators, also have the sensitivity to not only understand what may be going on, but also try to address it in a manner that is best serving all participants, the consumers, the applicants, the licensees, the boards, the academic community, the trade associations, whomever it is it might be. And so I'm saying this now because some of the things I'll talk about later in the slides, especially a couple of the cases that I will address, will be focused on an adverse action against a licensee. And that's not always the way that these matters could or should be resolved when we talk about impairments themselves. And so I'm trying to set the stage here a little bit about the sensitivities to all the perspectives, but the bottom line is you as regulators have to do what's right for the legislation, the intent of the legislation, and ultimately the consumers and the public that you are to protect. But let's make sure that we at least keep an open mind and we try to address some of these sensitivity issues as well. So this is the description of where we're going today. So it's in the slides. The slides are made available, by the way, to your organization, FSBPT, and I'm sure that they can make it available to you if you would like to continue access to those slides. So I like to start out when I've addressed issues related to impaired practitioners is this whole notion or concept of well-being, the state of being comfortable, healthy, and happy. Now, while that may sound a certain way, it is important, as I've already started to allude to at least, is the burnout and other issues that can confront practitioners. And that can lead to those that leave the profession. It can lead to shortages. It can be workforce issues. It can lead to a lot of personal issues that may drive someone into a state where they don't want to be, dealing with either mental health issues, alcohol, substance abuse, as you name it. And so I kind of like to start out at least on this well-being perspective approach that we all should have as humans, but we all probably should have as regulators as well when issues do surface and eventually come before you as a regulatory body where an important decision has to be made. And that is not to say that decision should not sanction someone, but that is just saying we have a lot of issues that we can bring to the surface to ultimately arrive at what I will consider to be the right decision. And by the way, speaking of the right decision, I am very much a proponent of group decision making. And so the right decision will be the 7 people or 9 people sitting around the table ultimately making a decision. There may be outliers here and there, but that group decision making, I think, will result in certainly taking into consideration the well-being issues, in addition to obviously these public protection matters that do surface. So kind of that well-being is supposed to set the stage here before we get into some of the adverse and other actions that can occur that might be adverse to a licensee, or of course the consumer that may be harmed. So if you want to type into the chat now is yes or no as to the availability of a wellness program for physical therapists and physical therapist assistants in your jurisdiction. And if someone is willing to, and Rich, I think people can unmute. Can you unmute someone and allow them to speak? So if someone says yes to this, are you willing to unmute and give us just the thumbnail sketch of how the program works within your jurisdiction? And that helps set the stage, because my comments will try to address the various options and programs that do exist, but it's nice to hear from an attendee who is on the front lines, if you will, that can speak to that. So I see a couple of yeses there. If anybody is willing to or would like to unmute and just give us the thumbnail sketch, feel free to do that now. I can keep going if that's necessary as well. But I see a few chats here, yeses. There is now a no. And by the way, if you do not know the answer to this question, you can type "I don't know." That's perfectly fine as well, because it provides us with opportunities to realize where there may be some additional education that could be had through FSBPT, as well as right there within your own jurisdiction. I will say that these, I'm calling it a well-being program. They may be substance abuse programs. They may be impaired practitioner programs. They may have a whole lot of different names. And everyone should understand that in many jurisdictions, these programs exist outside of your practice act as a physical therapist or physical therapist assistant. And it applies to all the regulatory boards perhaps in your jurisdiction. So you may not be used to seeing it. You may not have talked about it much, but these are questions that eventually you can ask your attorneys and your staff and executive directors, administrators about how this might work. Because if you haven't been confronted with a impaired practitioner yet, it's likely you will be in some point in the near future as well. And that kind of leads me now to some continued foundational issues about terminology. And we can call this impaired practitioner. That's fine, but we can call it disorder, dysfunction, disability, impaired, substance abuse, mental health, physical capabilities, cognitive, financial, toxic work environment. There are so many issues that, in my mind, could lead us to say, are we dealing with a practitioner who is under a certain circumstance that is worthy of or in need of some assistance? Generally, we all will jump to the conclusion of either alcohol or substance abuse. And that would be the probably the majority of matters that do come up. But just don't forget about mental health, disability, physical and mental disabilities and others that might exist, physical capabilities and cognitive issues and others. So we do have to at least arrive at some consensus on the terminology we want to use. I will use impaired practitioner mostly through the rest of this, but I just don't want this to be overly focused on substance abuse and alcohol, because there could be others. Most of the cases that I see do deal with substance abuse or alcohol, but there are additional factors that we need to be sensitive to and care for. So a couple more yeses came up, and a voluntary program came up as well in the chat. So I think you all can see the chats. So feel free to chat with each other if a question comes up about in Connecticut, yes, and how does it work? So these are the times for you all to make these types of connections. So using the word impairment now is perhaps we do need to define that. Traditionally used impairment refers to a problem with a structure or organ of the body. And, we can figure out a whole lot of definitions to this. And I will say this, I do assist most of my clients in drafting of their model legislation. And we have had some serious discussions over the word impairment or impaired And does it need to be defined? Should it be defined? And if yes, how is it defined? I pulled this just off the internet because I kind of liked it because it starts to differentiate impairment from disability. But either way, at some point in time, we might have to decide, well, is someone impaired? And they come before your board, or they're in a process of an adverse action, or there's a complaint against them, or they wish to voluntarily enroll, if you will, or register within a program that might be available in your jurisdiction. And at some point in time, somebody makes the decision that they're impaired, that they're entitled to the benefits of a program. And one of those benefits might be is that you as a board defer an adverse action. You do not take an adverse action while these individuals attempt to remedy their circumstances, right the ship, and continue on or come back into the practice at some point in time. So this impairment, it's a hard term phrase to define. And it's something that we at least want to continue to lay a little bit of foundation for as to the role that these words and phrases do play. So I've emphasized it maybe enough already, but I want these slides in here to remind me and to remind all of us on the line today about this as a balance issue. It's a balance between the practitioner and the consuming public that is in need of and entitled to protections under a statutorily set licensure process. And so I don't want to overemphasize this either, but I do want to just make sure that we all continue to think about this balance and take into consideration the issues that surface. And so we might ask ourselves, well, the severity of the issue at stake, okay, perhaps that's one, or the post-complaint, someone has been harmed approach to addressing an impaired practitioner versus a voluntarily come forward prior to complaints and prior to perhaps something that has gone wrong, or someone has been harmed where now you're asked to step in. But this balance is there. I encourage us all to keep it in mind, but we do not ignore the important ultimate responsibilities of consumer protection through the enforcement of the Practice Act itself. So we eventually have to ask ourselves, well, how does the board know about an impaired practitioner? And it's a really interesting question, and we can come up with all sorts of ideas. As one is, should the board know, or are these programs set up to allow someone to attempt to remedy their circumstance and without fear of an adverse action on the administrative side? Okay. So everybody on the line, you already know this, but I'm going to say it anyway. You deal in the world of administration. Okay. You are not criminal prosecutors or adjudicators. You're not civil adjudicators. You're in the administrative world of licensure, granting, removal, renewing, sanctioning, recognition of all the important things that you do as regulators. So is one of the issues here is that should you know about an individual who is, and I'm going to use impaired for now, who is impaired and is willing to come forward. And so this is a very important question, because in some jurisdictions, you will see the programs exist where the practitioner will go to this program, which is outside the parameters of the board, and the board will never find out. Is that a good thing? Is that a bad thing? We can think about it, we can talk about it, and we can identify additional circumstances that might make it important for the board to know. And we could probably identify some circumstances where the board may not know. Did I say that? Did I say them both? But anyway, know versus not know. So how does the board know? Well, I suppose I can self-report, right? And what am I going to self-report? And ask yourselves that in your law, where, how, when am I required to self-report? So I get pulled over for a DUI, okay, and I'm actually arrested, and the charge is now pending. Do I report that to the board? So some of you go ahead, write it in the chat. What is the answer to that question? Do I report that immediately? Do I have a period of time I should report it? Do I wait until the adjudication by the courts? Do I wait until the renewal cycle that comes up? Because at that point, you should be asking me, but how does the board know about this? And my next slide says, when does the board know? So I'm mixing these two, I'm kind of merging them together, but At what point in time am I obligated under law, if ever, by the way, to notify you as the regulators of the circumstance that has now arisen? DUI is the easy example, but there could be many other things related to one's mental health or substance abuse driven issues or others, but we'll probably use the DUI because it's easier to describe that and identify the various points in time that a DUI will matriculate, eventually resulting in either a conviction or an exoneration, or at least a plea by the defendant, who ultimately may be a respondent in your world. So as we get our terminology straight, licensees who are under investigation or via complaints, we can call a respondent. So anyway, so how does the board know? And do I self-report? And so I see one typed in here that it's at renewal. Okay. And many of you may not know the answer to this question. And this may be true on not only impaired practitioners, but a host of other things that might be existing in my world as a licensee who may or may not have to report any activities that do exist here. So someone else is typing in a misdemeanor is not considered a basis to withhold a license. Okay. And with that said, now, since we're opening the door to this criminal issue, everyone ought to know that in the climate we're in, that I've already started to describe, there is a significant amount of legislation that is addressing these second chance issues that can surface. Meaning, if I have a criminal conviction, it's 5 years old, it was a minor infraction, it was, say, a misdemeanor, as indicated in the chat here. Legislatures are starting to say that is not even able to be considered as part of a licensure application or perhaps renewal process. And we might make that same argument related to DUIs, mental health issues that may have surfaced or otherwise. So we need to be aware of the climate and the politics that is going on legislatively to try to address these second chance issues. So back to how does the board know? I could self-report. Someone else could report me, right? That I'm impaired, or they think or they believe me to be impaired. There may be a complaint that comes in, and it could come from a consumer, could come from a fellow employee, a peer, another physical therapist or physical therapy assistant. It could come from an employee of a physical therapist, or the circumstance where there is an employer-employee setting. So this is how the board will know. And now the question will be, well, now what do you do? And how do you address these particular issues? So we've talked a little bit about this how and when. And this is a really important question that you ought to know the answer to. So somebody typed in here within 30 days of conviction. So that conviction, by the way, may take a while. We know in criminal settings, there's a speedy trial, yes, but it's not going to happen overnight. And so my DUI arrest may not be adjudicated for a bit of time. And am I able to then still work? Am I able to refer to my license as being in good standing? And if the answer is going to be yes, I guess, to both of those, if I don't have to report it right away. So one thing to maybe jot down is, do I have to report arrests as opposed to convictions? And everybody ought to know the criminal settings that we deal in. There's arrest, charge, conviction, or exoneration, pardons and expungements. And so that's the full breadth of what a criminal matter has. And so I would ask you, do I report upon the arrest? Do I report upon the charge? Do I report upon the conviction? And then we'll leave pardons and expungements for another day. But the point is at what point in time do I need to? You ought to know the question, answer that question, and your licensees ought to know that. It's probably going to be in the law somewhere, and it may not be in your Practice Act. So you do have to learn to ask these questions and engage your lawyers and help have them help you with identifying these issues. And by the way, if it's identified and you think it's not known, make it be known. Post it on the website. What I like to recommend that boards do is issues like this, for example, maybe put on the renewal applications. As a reminder, statute and cite the law. One who is subject to an arrest must report that within 10 days to the board. And you just remind them of that gently. It doesn't need to be a test. It doesn't need to be, it doesn't mean you're going to refuse to renew their license, but you're just getting the word out in some way, shape, or form. So these are some ideas you might want to consider or at least think about. And when does the board know? Now, the applications and renewals are, to me, the starting point of when a board should or could know about a particular matter. Most likely it may be on a renewal, but it could be on an initial licensure application. So you do need legal advice on the issues related to your applications and renewals. How do I phrase these questions? So perhaps that question says, do you possess the physical and mental capabilities to safely and effectively practice the profession? Okay. And that's a very broad question versus, have you been treated in the last X, or let's start with ever. Have you ever been treated for a mental illness? Have you ever been treated for alcohol abuse? Have you ever been treated for substance abuse or drug abuse of certain times? Have you ever been subject to a diversion program? We can think of a lot of questions. So the reason I'm emphasizing have you ever is the Americans with Disabilities Act will eventually rise up and limit your abilities, not abilities, it'll limit the way you can phrase your questions. So the days of have you ever been anything are probably gone, and you need to put a period of time wrapped around that. In the last 5 years, have you? So if you're going to modify your applications and renewals, get some legal advice on that. And by the way, while we're on that topic, if you haven't looked at your applications for licensure and renewal lately, you ought to. And this is one reason why, what we're talking about, but there's a host of other reasons that that will probably jump off the page at you when you read your applications for licensure and renewal. Hey, do we need to know this? Do I need to know you're left-handed? Do I need to know that you're 6 feet tall and you have red hair? Or do I need to know you're married or anything else? And so decide what you need to know and leave it in. If you don't need to know it, you might want to consider taking it out. But specific to our topic today is you're going to need some legal advice as to how to phrase those questions so that people will, if you will, self-report by accurately responding to the questions you have on your applications for licensure and renewal. And so you're going to be very careful about that. And the final point on this issue is don't tie your renewals to the last renewal cycle. So if you have a two-year renewal cycle and your lawyers say you can ask in the last 5 years, have you been treated for mental health or substance abuse? Okay, let's say you're going to phrase it that way. Every 2-year renewal, I would phrase it the exact same way. In the last 5 years, have you? So that you have enough overlap, number one. And number two, you have consistent questions in case someone decides to not be honest with you, and that you have an easier mechanism to show that their answer was inaccurate. And the reason I say that is, and I don't want to make this too long of a story, but there's a case not too long ago, did not deal with physical therapy, but it dealt with a renewal application, said, since your last renewal, have you been treated for drug or alcohol abuse? And the candidate got the renewal 90 days before the expiration date, immediately checked in to rehab, was out in 30 days, and then come renewal answered the question, no, I haven't. Because at that point in time they had a dispute over this, and the court said, well, the way the question's phrased, this person was accurate in their answer. So you want to be a little bit careful and don't allow these cute, coy answers that might surface. So one way you find out is right here in your applications and renewals. Get some legal advice as to how to phrase some of those questions. I've mentioned the Americans with Disabilities Act, which is federal law. You all should know about that, signed into law in the early 1990s and has been amended a few times since. The ADA will come into play when it comes to phrasing of these questions. But don't forget there are applicable disabilities laws in each of your jurisdictions as well. So seek some advice here. Make sure that as you consider modifying your applications, that you get that legal advice and that you phrase your questions accordingly, consistent with what your lawyers are telling you. So it's not always just ADA. There may be applicable local laws, state laws that apply to you related to this particular issue as well. So seek some of that advice and follow it. So now we get into the meat, if you will, of how is this issue even being regulated. And most likely you will find it in your statutes. And as I've already mentioned, it may not be in your practice act. In fact, most likely it is not in your practice act. It is in an overarching act that addresses all the professions within your jurisdiction and allows a mechanism for individuals to perhaps seek a safe haven, if you will, related to an impairment and try to right that ship without having the threat of their license being taken away. Again, that's back to the balance slide, and I'm not overly emphasizing it, but again, it's an important factor to consider. So how is it regulated? So your model act says the board may permit a licensee to actively participate in a board-approved substance abuse recovery program if, and it's got some criteria there. So in a customary, and you all should all learn this, you all should know this, and you all should learn to ask questions related to how statutes are phrased. There's nothing wrong with that. And everybody's entitled to not only that opinion, but most importantly, you are entitled to it because you have to enforce your practice acts consistent with the intent of the legislatures. So one is you ought to read your practice act. So that's first and foremost. And if you haven't read it lately, read it now. And I think words would start to jump off the page at you. And two is read the portion of the acts relevant to your profession, physical therapy and physical therapy assistance, that might relate to these recovery programs or otherwise. So the reason I gave that little long-winded start there is the board may permit a licensee. So that word may is really important. Well, gee, I guess the board could say no if the may is in there. And that's a question I would at least ask. And, and that's a legitimate question, but so at least we'll start there. So under the sub one there, and the board may permit a licensee to actively participate in the program if the board has evidence that the licensee is impaired. So now we have to decide, well, gee, what is impairment? And we've already talked, that's not an easy term to define. And you will get a lot of different opinions about what impairment actually is. But it also now says the board has evidence that the licensee is impaired. So is a complaint evidence? Is a self-disclosure on an application or renewal evidence? And at what point in time might it not be considered to be evidence? And I'm only doing this, I'm just picking on words, and this is what lawyers get paid to do in part. But, this teaches us to read all of these carefully, all the practice acts and your regulations. It teaches us to read them carefully. Now, interesting under sub 2, and I don't think I saw this in any jurisdiction that I looked at. And under sub 2 is, remember, this is that if the licensee, so this is a if you will, requirement under that may permit, but it's a requirement if you're going to allow it. The licensee enters into a written agreement with the board for a restricted license. So that's an interesting issue. Well, let's see, restricted, can't practice, limited practice, full practice. I'm not exactly sure what might be intended here. And it goes on there and complies with the terms of that agreement, which is, of course, if you entered an agreement, you have to comply with it. But a restricted license as a right out of the chute as to the permission of that licensee to enter into this program itself. So I think there's an assumption being made that a licensee who is going to take advantage of the substance abuse recovery program must have a restricted license. And there's nothing wrong with that assumption, but this is an interesting point that I found in your model act. And I didn't see it in any other statutes. So, it's something for us to all just reflect upon and think about. So, under sub 3, you can see there as part of the agreement, the licensee signs a waiver allowing the substance abuse program to release information to the board. And so pretty customary there that the board has a right to know what's going on so that you, the board, can effectively carry out the intent of the legislation of public protection. So that's just a start there. And just a couple other examples here, and these are randomly selected, not picking on any jurisdiction at all whatsoever. Just a couple random selections because there are so many varied approaches to this issue of impaired practitioners and how you administratively deal with them as regulators. But the board, so here's Alabama. The board shall provide for an impaired practitioner program beginning, and there's a date there. It started several years ago. And the board shall promote the early identification, intervention, treatment, and rehabilitation of physical therapy licensees who may be impaired by reason of, and it's got a list there. So here we are now with the two shalls as opposed to the previous slide with a may. And we'll ask ourselves, well, what's the difference? And is there a difference? Should we concerned with it? Well, we may or may not be. But the point is that that word should jump off the page at us all now and say, well, the board is required to do something in which it says promote the early identification. So I'm not exactly sure how a board promotes the early identification, intervention, treatment, and rehabilitation, but there's a mandate here in my mind that the legislature intended by enacting this particular law. So the board has to step back and say, well, gee, how do we comply with this? So that's one big issue. We throw it out onto the table there, but keep reading there. So it's an intervention, treatment, rehab of physical therapy licensees, which I assume includes assistants, who may be impaired. And there's that word impairment. But look at the limiting language after this: by reason of illness, inebriation, excessive drug use, narcotics, alcohol. And that may sound very broad, but it is now a limiter because the statute, the legislature decided to say that impairment has to be by reason of the following. Otherwise, perhaps it's not subject to the application of this law. And again, this is very lawyerly sounding, what I'm saying now and all that, but it does help us when we learn to read issues like this and ask the questions of how does this really apply? So here's some shalls, here's some impaired language, here are some conditions that apparently must lead to that impairment, that allow then the practitioner, the licensee, to be the beneficiary, if I can use that word, of one of these particular programs. Now, here's Kentucky's: the board shall establish an impaired physical therapy practitioners committee. And I see a lot of jurisdictions where there are committees established. So if you all have a committee, and to make sure you're still listening and that you're out there, type something in the chat that you have a subcommittee of the board or some other type of a committee that deals with impaired practitioners. Just let us know. It's good for us to see that. It's good for the FSBPT staff to see it, as they also prepare not only programs for you all educationally, but model acts and other guidance documents that exist. So the board shall establish an impaired practitioners committee to promote the early, again, here's that early identification, intervention, treatment, and rehabilitation of physical therapists and assistants who may be impaired by reason of, and there's some more, illness or of alcohol or drug abuse, or as a result of any physical or mental condition. So that is broad language, I guess, but and then you can see under number 2 there is that the board may enter into a contractual agreement with a nonprofit corporation that can provide the expertise, so to speak, for these services. Many jurisdictions have that. Many have that. So this is the, if you will, the norm of how a board may address situations like this and engage the expertise of outside entities, in this case, not for profit, but outside entities that can help you navigate your way through what is a very difficult question. And so somebody typed in there, there's an investigative committee. So Kathy, Rich is going to send you dinner for 2, a coupon for that because you responded to that. So thank you very much. And that's just kidding, by the way, in case anybody really expects that. So in the end, here's an individual who is impaired, falls under one of these statutory issues, is either voluntarily allowed to or is made to and shall and is imposed upon them. They're going to go through one of these programs. And in virtually every case I've ever seen, it's the licensee who pays for this. But it's an interesting question to ask. And do you have recovery funds and others that you are allowing a reserve to build up? And what do you use that money for? And so I think it's Idaho that I saw has a recovery fund, and they're allowed to collect up to $50 from every licensee from every renewal period that goes to a recovery fund. And so the question is, well, where is that money? How do you use that money, and who gets to benefit from it? And part of it, of course, might be to pay the nonprofit, according to is that Kentucky, the nonprofit group. There may be some consequences or payment options there, but the licensee generally will have to pay their own way, if you will, to participate in those. North Carolina is also chiming in here about putting money toward each case with our program. And so, toward each case is the beneficiary of that money then is the impaired practitioner, I assume. And if I have that wrong, please correct me in the chat or unmute to speak. But there is a monetary side to this entire discussion we're having that we need to keep an eye on as well. Safe haven issues. There's language being drafted. I'm working on a couple for my clients now about safe havens, which is trying to, and thank you for the correct deal. What they're trying to do is create this process, as I've mentioned multiple times, where if I voluntarily go into something, that I can attempt to right the ship here without the potential consequence of loss of licensure. And these need to be very carefully drafted so that in the end, the consuming public is ultimately protected. But as I've talked about, the balance and the sensitivities to the practitioners can be an important factor as well. So you might see some safe haven language that starts to surface in your jurisdictions, or you might be authorized to promulgate regulations that address those issues. I've probably talked enough about this public-private involvement, but these programs exist, and we've already identified a few in some of our examples where your board contracts with a private sector group that provides the expertise necessary, the oversight, the testing, and anything else that might be needed to, one, identify the impairment, and then two, allow an opportunity to resolve, to remedy, to right that ship, as I've said multiple times. And so that public-private relationship can be very important and can provide some of these opportunities. Before I get into a couple of cases, just lastly now is related to information. Well, who gets access to the information? And what if the consumers call and ask? And so it's a really interesting question. If your board knows, because you have put Dale into a rehab situation, allowed me an opportunity to do that, and I call and someone else calls and says, is Dale's license active and in good standing? You're going to have to answer that question. Well, hey, is Dale in rehab? How do you answer those questions if you know about it? And as I've already mentioned, sometimes you don't know about it. So there's no easy rule that can be drawn from the research that I've done and the engagements that I've spoken at to try to address this. But keep in mind, you may not know that you as a board may not know that one of your licensees is engaged in or taking advantage of, in a good way, by the way, taking advantage of one of these programs. And at what point in time do you get to know? Usually is if there's a non-compliance with the program and there's a waiver already built in that automatically the administrator of that program will tell the board. And now you have the right to act, or perhaps the obligation to act if you know of this impaired practitioner who is engaged in activity and or is failing to comply with the program itself. And so a little bit here, board access to information. That's kind of what we talked about already now. And does the public have access? And at what point in time can you tell the public and allow that to actually be disclosed, if you will? And there's a lot of sensitivity around this, and there's a lot of confidentiality statutes you do need to be aware of. So get some advice. The awareness issue of impaired practitioners and otherwise is again, it's much more front and center than it used to be. And there are some jurisdictions that have CE requirements that as part of your renewal process that you, licensee, have to take CE related to impaired practitioners. So that may exist out there. And if anybody wants to type into the chat there, I see Ohio has implemented a safe haven program. And so if anybody else wants to type in, do you have CE requirements that cover impaired practitioners and recognition of and dealing with, if you will. So those do exist out there. I've already mentioned the pre and post complaint enrollment. If I have a voluntary enrollment and I wait until there's been harm done, I myself think that should be looked at differently than if I voluntarily enter the program prior to, if you will, wrongdoing or harm to the consumers themselves. And lastly, and I had trouble finding the answer to this question is at what point in time is there mandatory reporting? Where I, as a licensee, believe that my fellow licensee is impaired, do I have to report that? and what are the obligations and what are the consequences for non-compliance with that. So be thinking about how those might come into play. So a couple of cases here in our last few minutes here, but if anybody has any questions, type them into the chat now. I am going to talk about two cases that are I think some interesting fact patterns that help identify, and they're kind of complex, so I have to get some notes out here in front of me. But the Sullivan versus Kansas State Board of Nursing, it's obviously a nursing case. We have an individual who was arrested for a DUI, okay? And so that's kind of our customary approach to this, arrested for a DUI. Now, factually, this person was licensed in 2007. In 2011 is when she was arrested for driving under the influence. Now, the judicial opinion says later that year, she reported the arrest to the board. I don't know what that means. I don't know when it was reported, and I didn't research the obligation for this nurse to self-report. And I've already asked this question, and you all ought to know the answer to this question. I don't know the answer, but you ought to know so that you can appropriately enforce that. But she, by the way, was over twice the legal limit when she was arrested. So it's probably more of an egregious case, if there is such a thing as to a minor, and I hate to say it that way, DUI, but she reported it later that year. Then it says in February of 2013, she again reported the DUI on her renewal application. So she did both. And I'm guessing she probably had an obligation to do that. The board sent her into a rehab program. They have an arrangement. They have this whole process where they follow. And what's interesting is the process followed. I'm not going to get into too much of the details here, but in the end, she had two evaluations done, and both evaluations said that she had a low probability of having a substance dependence disorder. Low probability. However, both said she had a high defensiveness scale, which in the end is a masking, if you will, of what may be a substance abuse or dependence issue that's at stake here. So based upon that high defensive scale, she was asked to go through another rehab program. She ultimately refused to do that, and her license was revoked. And that revocation was upheld by the courts because there was a reasonable nature to the probable impairment that the board concluded, and that she refused to go through the program that was ordered, if you will, by the board. That was the mandate. That's back to that mandate issue, because it did end up coming before the board itself. So there's a revocation, and that was upheld. One of the issues, by the way, that the court emphasized is that she entered the second program voluntarily. So her entire argument saying, I'm not impaired, they said, well, you entered a second program for impairment. So we will, if you will, interpret that, if you will, against you, and determine your impairment issue. I see a comment about nurses are under a different board than PTs. I understand that. I bring up these cases because I didn't see any PT cases that dealt with impairments, and a couple of these had some good facts that identified issues that are important across the board, no matter what profession you are regulating. So just a little bit about that particular issue. And then the second case, so again, that was a revocation that was upheld. So this is a person who had one DUI and resulted in a revocation of licensure. And let's define revocation. I get it, and I talk about that a lot, but what does that mean? Can this person get their license back? But in the end here, this is one DUI that ultimately resulted in a mandate to go through a program, and then a refusal to go through the program, which is what resulted in the DUI. The court specifically said that her revocation of licensure had nothing to do with her competence nor any on-the-job issues. And so it's not like she was got a DUI on the way to work. This was a social setting that was never tied to work itself. Again, perhaps an important factor that exists. The second case is also, it's not a PT case, but it is an osteopathic medicine case where a licensee was arrested twice for driving under the influence. He reported his arrest to the board. some complaints also rolled in about them, and he voluntarily sought the program assistance in Washington State. It's the Washington Physicians Health Program, WPHP, and he enrolled in that. And eventually the board suspended his license to practice while he was in the enrollment. And what I like about this case, and I don't want this to sound insensitive to impaired practitioners in today's entire topic, but what I like about this case is Washington statute requires a formal charge and the ultimate disposition both to be publicized through a news release. So how interesting is that? Now the board, when a matter ripens into a formal charge, it must issue a press release that says Dale is charged with unprofessional conduct, let's say, or impairment or whatever is being alleged against me, and that is going to be told to the public as a whole. Then the board adjudicates the matter. It finds me guilty. It removes my license or sanctions me in some way. It has to publish that final action as well under statute. I think that's a great statute. I realize that today's topic isn't the best place to bring up this topic of, if you will, mandated disclosures. But in the end, I do like an informed public, and I do like boards that actually publicize their final adverse action. So he was arrested twice, once in Michigan, once in Idaho. He actually pled guilty in one of the cases, but it was a deferred judgment. So if he behaved for the next 2 years, they wiped the slate clean. So what the board did is and this turns into an immunity case, so it's not an impaired practitioner issue per se, but what the board did is they published that he was convicted of DUI, and that was not a true statement. So what did this physician do? Sued the board for damages. It's turned into an immunity case, and the board was successful in having it dismissed out. So the bottom line is mistakes might be made, you bet, and you all have immunity, so make sure you do realize that. But it was an interesting case because it did deal with a couple of DUIs and the conclusion of impairment of a physician in the state of Washington. So as we kind of wrap up here in our last couple of minutes, and if anybody has any questions that you want to ask, feel free to ask them. I threw in a slide here about workforce issues because this is kind of all the way back to the burnout, the mental health issues, and others in many professions are leading to shortages, and that puts pressure on the on the politicians, the elected officials, the decision makers, as to how do we address some of these shortages. And burnout is one of them. And burnout, I think, can lead to some of these mental health, substance abuse, and alcohol issues eventually. So at least let's be savvy to, aware of that particular issue itself. I kind of want to wrap this up with the awareness factor that we talked about to begin with. Is there are sensitivities to all sides to this, but do your jobs as regulators, protect the public ultimately, and understand that. So kind of the overview of this is there are programs that exist. Some are voluntary, some are not. Most of these programs deal with the private sector, and a contract between a board or a department within a jurisdiction and a private sector entity that has the expertise to do this. Under many circumstances, you as a board will not find out that a person is in this program unless something goes wrong. But if complaints come in, do your jobs and ensure that you are protecting the public through the enforcement of the practice acts themselves. There are many variations of how these are addressed from jurisdiction to jurisdiction, but I'm hoping that my remarks today at least laid a little foundation for the perspectives that are there and some of these options and some of these programs that do exist from that. So I will end my remarks, but answer any questions you have them as I started. A gigantic thank you to FSBPT for putting on these webinars and allowing me to be a part of it. But the huge thanks certainly goes to each and every one of you on the line today for your important role you play in public protection through the enforcement of the Practice Act. So, Rugi, I'll turn it back to you. But if anybody has any questions or comments, I'm happy to answer questions if I possibly can.
Yes, thank you, Dale. I appreciate it as usual. Very valuable information. As hopefully folks get a chance to formulate some questions, I want to point out that in the chat, looks like Rich or Caitlin may have posted that there was a closely related webinar that they provided the link in terms of the challenges for healthcare professionals management of substance use disorders. So just please make a note of that. So I'd like to give a few seconds to allow people to possibly ask questions if they may have any. While that, and I would like to thank the 26 participants who signed in for this. I'm very grateful and we're very appreciative of the participation. Well, I have a question for you then, Dale, because hopefully this will lead to some or further questions. Your opinion about voluntary suspension. And again, I cannot give specifics, but the reasoning behind voluntary suspension or trying to lead into a impaired practitioner with voluntary suspension is that if a board enforces a suspension, an involuntary suspension, it fast tracks that process because, you know, there would be right for hearing and so forth. What are your thoughts of voluntary suspensions? Any experience with it? Comments? I hope I'm making sense, right? Because that would be the preferred way that a board would behave, I guess. Your thoughts?
If I could talk about hockey for 4 minutes, then the webinar would end, and then I wouldn't have to try to answer that. No, I'm just kidding. Anytime I hear the word voluntary, now there's the voluntary side where I as a practitioner can voluntarily go into a program and try to write, myself and right the ship, if you will. The voluntary suspension, to me, I don't ever like the word voluntary in front of a suspension, because actually a suspension is your board says, hey, Dale, you're impaired. We believe you to be impaired. We have credible evidence that you are impaired. So therefore, we are going to remove you from the practice. You may agree, but I don't need to put the word voluntary. That is an agreement made between between the licensee, me, and you, your Oregon board, or it's an emergency suspension based upon whatever circumstances exist. So I try to leave the word voluntary out of the reference to a suspension or a surrender of a license or anything else, because it's a board imposed issue in my mind if it's a serious circumstance. But in the end, I think you're correct. The overall comments that you made are correct. It can speed up the process. The public might be better protected if I am not practicing during my my time of rehabilitation, let's call it. Did that answer your question? I hope so.
Oh, absolutely. I was just curious. And again, I'm not speaking, I no longer represent the Oregon board, right? I termed out, but I was just curious because of my exposure to various boards and whatnot. So I'm not speaking on behalf of the Oregon board. Doesn't look like we have any questions. I mean, I've not seen any. I guess we would like to give them a few minutes. Looks like you've answered all the questions, Dale, because we do not have any at this point. So I thank you. I thank all the participants. And again, please do not forget the next educational offering for the regulatory on our webinars. And that would be with Lauren Mueller and Colleen Letvin on March 1st, the when, how, and why of MPTE design. And we'll see you then. Thank you so much. I appreciate it.